In 2022, the independent testing lab ConsumerLab.com purchased magnesium supplements off retail shelves and sent them to analysis. One of the most popular magnesium gummies on the market came back containing 42% of the magnesium it promised on the label. Not a rounding error, not a measurement variation. Less than half of what thousands of women were auto-shipping every month, recommended by their doctors, reviewed with 5 stars by people who had no way of knowing what the lab had just found. The company was not investigated. The product was not recalled. No law was broken, because under current federal law, none of that is required. No law. The bottle on the shelf may contain exactly what the label says. It may contain half. It may contain none. And the company that made it, the retailer that stocked it, and the federal agency theoretically responsible for overseeing it are all operating entirely within the law regardless of which of those 3 things is true. May contain. This is not a conspiracy. This is the Dietary Supplement Health and Education Act of 1994, legislation that removed supplements from the FDA pre-market approval process that governs every drug sold in America. The supplement industry generates over $60 billion in U.S. revenue annually under a regulatory framework that has not changed since it was written for a market a fraction of that size. Dietary supplement. The gap between what you believe you are buying and what the law actually requires that bottle to contain is not a bug. It is the business model. In this investigation, we are going to show you the 1994 legislation that created the loophole, the label claim system that is technically legal even when the product contains a fraction of what it promises, and the certification theater that exists not to protect you, but to protect the industry from the regulation that would. This is not a quality control problem. This is a permission structure. In 1993 and 1994, the supplement industry faced a genuine regulatory threat. The FDA proposed bringing vitamins, minerals, and herbal products under the same pre-market approval framework that governs pharmaceutical drugs. A manufacturer would have to demonstrate safety and efficacy before a product reached shelves. The industry responded with one of the most effective lobbying campaigns in modern consumer product history. Consumers were told the FDA was trying to make their vitamins illegal. Congress received more constituent mail on this issue than any topic since the Vietnam War. An estimated 2 million letters were sent. The result was the Dietary Supplement Health and Education Act, known as DSHEA, which was signed into law in October 1994. Under the Dietary Supplement Health and Education Act, DSHEA, supplements occupy a separate regulatory category with a separate standard. Manufacturers do not have to prove their product works before selling it. They do not have to prove it contains what the label claims. They do not have to notify the FDA that the product exists before it ships. The FDA cannot remove a supplement from the market until the agency proves the product causes harm. The burden of proof sits with the government, not the manufacturer. The industry has successfully blocked every major regulatory overhaul for more than 30 years. The framework has not changed. The market has grown 60 times larger. The gap between the two is where your money goes. The label on a supplement bottle is not a guarantee. It is a claim. The FDA is not required to verify it before the product reaches the shelf, and in most cases does not verify it afterward. In 2023, a study published in JAMA Network Open tested 57 popular supplements and found that 40% contained none of the active ingredient listed on the label. Of the products that did contain the ingredient, the actual amount ranged from 0.02% to 334% of the labeled amount. Every one of those products was legally on the shelf. Every one was in full compliance with federal law as written. Structure function claims are the language that says a product supports healthy sleep or promotes immune function, and they are not required to be proven before use. The manufacturer must have substantiation on file that the claim is truthful. That substantiation does not have to be published, independently verified, or submitted to any regulatory body. It has to exist in a file somewhere in case the Federal Trade Commission ever asks. The Federal Trade Commission rarely asks. After DSHEA passed, the industry understood consumers would eventually learn what the law did not require. The solution was not stronger manufacturing standards. It was the appearance of stronger manufacturing standards. Third-party certification programs, NSF International, USP Verified, and Informed Sport, emerged as the industry's answer to the regulatory gap. A manufacturer pays a fee, submits to an audit, and earns a seal that signals independent verification. The testing behind these programs is real for the products that carry them. Industry experts estimate fewer than 1 in 10 supplements carries a legitimate third-party certification from any of those 3 bodies. The seal on the bottle is almost certainly not one of them. It may be a logo that resembles a certification seal. It may be a house program the manufacturer created and named themselves. It may be nothing dressed in the visual language of independent verification. The certification system did not fix the loophole. It gave consumers a reason to stop looking for it. The certifications worth trusting are NSF International, USP Verified, and Informed Sport, not a similar-looking seal, not a branded program with a generic name. Those 3 specifically. If the bottle does not carry one of them, treat the label claim as unverified. For any supplement you take regularly, search the product name plus Consumer Lab in the same query. Consumer Lab has been purchasing supplements off retail shelves and testing them since 1999. Their database documents potency failures by brand and product, including a magnesium gummy that contained 42% of its label claim and another that contained 242%, a potential overdose risk the label gave no warning of. As of 2025, legislation that would simply require supplement companies to tell the FDA what products they are selling has been stuck in Washington for a decade. Not safety testing, not efficacy proof, just a list of what exists. It cannot pass because the industry generating $60 billion a year has spent 30 years ensuring it does not. The magnesium gummy is still on shelves. The JAMA study is publicly available. The DSHEA framework is 30 years old and unchanged. The bottle looks legitimate. The seal looks official. The law says it is fine. It is not fine. And now you know exactly why.